probably referring to
the UKBA. Yeah.
Yes, it's the Home Office. It's the Immigration Department rather
no,
than
because
us.
there are many cases which are not being heard because of the RMJ case files are still not being transferred properly.
No, my understanding is absolutely that every single case has been transferred and had been transferred more than a few months ago.
Yes, I'm surprised
all the
to hear
paperwork supported as well.
Yes, could I write to you on that and confirm that? But that is certainly our understanding. So.
Okay.
And in terms of cover in Ipswich, again, what we will be doing as part of the whole Civil 2010 exercise is looking to see whether there are any gaps, and if so, how best we could try to fill them. But obviously there are always difficulties in trying to get rural services in particular access to specialist advice, because there might not be enough clients in an area to make it worthwhile in terms of commercial terms.
Well, Ipswich was one, Brighton was another. Neither are rural areas in their own right, and they also happen to be dispersal centres in some areas. So it was an unhappy coincidence. But you know of the problems yourself. I would be interested to know where you are with it.
I mean, just on RMJ, what actually happened was we did employ even though they'd gone into administration, we came to an arrangement with the administrators, and we employed their staff along with our staff to work together to transfer all the files. So we did put in place a large programme to ensure that people didn't actually slip through the net, but we'll definitely write to you to confirm exactly. Yeah.
Okay. If I could talk about the criminal aspect, and I have a number of questions. First of all, around means testing, you'll be aware of the considerable concerns that some have had about the delays caused by means testing. I was wondering if you could quantify what those delays are and what the increase caused by means testing is. And secondly, if you've established why the delays have happened precisely, and see what you're likely to do about it.
Yeah. The delays around mean testing are largely, I understand, related to Crown's Court means testing, which was introduced this year, and that's been rolled out in the summer of this year. There were, again, it's an issue around the quality of the information. That this is some work undertaken by HMCS rather than ourselves, and the work that they are receiving from solicitors and the claims that they're being put in are not sufficiently robust, and therefore they're being passed back from HMCS to solicitors so that the eligibility documentation coming forward is more rigorous. It is a real issue in London. I don't think it is an issue elsewhere at the moment. It has been, but I think that's been resolved. HMCS, the refusal rate at the moment that they are sending back forms on CCMT is about 40%, so it is a considerable amount. They have now put in additional staffing in London to address that issue, and I would hope that by January we should be back on an even keel with those applications going through appropriately. So it's an issue of new system introduced this year, probably insufficient resource put in London in particular, and also a new system where the information that is being given is not actually sufficient. And we have done a lot of work with the Law Society to actually try to resolve those issues. So working with providers, so the more accurate the information, the quicker the claims and the quicker the payment. So that's been actually a good piece of work of the Law Society, the Legal Services Commission, the HMCS working together.
You were looking forward to saying that, weren't you?
Oh, yes. Thank you.
Could I ask, again, have you been able to quantify how big the problem is, and when have you got a date by which?
Yeah. It's a 40% rejection rate at the moment in London. It was 25% outside London, but that's pretty well okay now. And January. I mean, I'm being pessimistic saying January. I think the briefing I got said probably mid-December, but given the way things are, I think it's probably better to say January.
On the issue of very high cost cases, what work have you done recently to look into what can be done to reduce the burden that they're imposing on the criminal legal aid budget?
Well, I think they've been managed more successfully, and I think we see a 30% reduction in the average cost of the very high cost cases since 2003-4. And I think that's a reflection of the scrutiny that LSC staff give to these rather difficult cases. And obviously the cost of these cases often is dependent on the number of matters, including, for example, pages of prosecution evidence, and these things are studied very, very closely indeed. And a tight rein is kept on, as you say, Mr. Gummer, something which is potentially very, very expensive.
Do you have any targets to reduce that figure still further? I mean, is there any strategy that you have yourselves to see the costs coming down more? Off the top of my head, I can't remember the figure, but we have reduced costs over the course of the past year or so, and we've brought in, there is now an independent panel, so where there is, in any case, a dispute between the solicitor and ourselves as to the costs that will be incurred, then we have an independent panel of barristers and solicitors who then work with us and the individual solicitor to mediate and negotiate an appropriate fee. We're also doing benchmarking of the type of costs that we would anticipate according to different types of cases. Obviously the most expensive being fraud and terrorism cases. As Sybil said, the reduction is a 30% reduction in very high cost cases. We haven't been set a specific target by the Ministry of Justice for this financial year to get very high cost cases costs down. But you don't have an internal one?
Not that we... No, we don't, no.
Okay. On a related issue, you're aware of the government's interest and in fact the whole particular frustration of the judiciary about plaintiffs changing their pleas at the last minute. Do you have any particular views on that which you are developing at the moment, which you might want to share with us?
Right, perhaps to speak also as a magistrate, and obviously I'm aware of cases going to Crown Court. 4 out of 5 cases in the Crown Court turn out to be late guilty pleas at the door of the court, and that's obviously very, very expensive. I mean, the issue is addressed in the government's legal aid reform paper, and that's obviously something we're giving close consideration to. But certainly, looking at the fee schemes, we want to make sure that there are no perverse incentives where people might favour that course of action.
Is it addressed sufficiently in your view? I mean, you said it's addressed. I know it's addressed in a rather broad brush manner, but is there anything more that you feel?
Forgive me. Obviously, we read the consultative document when it came out not long ago, and obviously we will be giving it, that and all the other proposals much further scrutiny.
Okay.
But I think that's one that broadly we would definitely support because we've got to incentivise through fee regime behaviours which actually reduce court time and reduce whole system costs, not just legal aid costs.
The defendant is incentivised by a discount on sentence.
Yeah.
There is, of course, the possibility that members of my profession, and I put it that way, might be urging clients to plead guilty when, strictly speaking, they should have the day in court.
That's true. Yeah.
The perverse incentive could be there.
Yeah.
But there are also other members of the profession who know perfectly well the point at which to... You're smiling. For a plea to... And it always seems to fall, no matter where the rules are changed, at the point of which it is of maximum financial advantage to themselves. I'm speaking here as a non-lawyer, I'm getting the evil eye maybe. Is it possible to design a system which avoids that, or do you think that's just a...
Well, that is what the Ministry of Justice are looking to do, and they've set out some proposals in their consultation paper. But obviously one always has to balance that with the need to ensure that the defendant is given every proper opportunity and fair access to justice. So it's about getting the tension between those two issues right.
Okay. Could I ask 2 further questions, please, specifically about the solicitor call centre? Whether you feel that it's working well, whether you feel that the bureaucracy is merited, whether you believe that it's value for money, or whether things could be improved. You know of the Law Society's views on the matter?
I certainly know of the CLSA's views on the matter. I wasn't aware of the Law Society having specific views, but I certainly knew of the criminal law.
Well, they think it should be scrapped.
Well, so does the CLSA, so they're obviously probably members of the same organisation. But I think, again, it's important to recognise why it was brought in. And it was brought in, one, to reduce costs. It did. It was also brought in to ensure that calls and defendants in police station got access to advice at the very earliest opportunity. The access to that advice was done in a transparent way, so that work went to solicitors who were on a rota, effectively, who tended to the work, rather than somebody who was known, perhaps well, within a certain police station. So it was undertaken, one, to provide greater transparency, to ensure that defendants and people who had been detained got immediate and early access to advice, which it has achieved, and to reduce cost, which it has also achieved.
So, how much did it cost and how much have you saved as a result of introducing it?
I know we just relet the tender for the service as a new provider, and that is saving, I know, £2.8 million per annum. And perhaps what...
Of what base?
My colleagues will give you the precise figure in a moment. There was some work done on the quality of the previous provider, and Legal Action Group did asked a couple of leading solicitors to examine the quality of the work, and I can just give you a quote. This is from Mr. Keogh and Mr. Edwards, who reviewed a sample of files, and they found that there were some minor issues, but taking the sample as a whole, the quality of the Defence Solicitor Call Centre was extraordinarily high. I'm quoting from that independent study. So,
just on the figures, in 2005-06, the value of work taken in police stations was £185 million, and that was 770,000 cases. In 2009-10, the value was £187 million, and the volume of cases was 853,000. So that does show a significant increase in the volume of work for a not dissimilar figure.
One further question on representation, because if I can roll this together, there are specific issues about the quality of representation for some clients, that have been brought up through the call centre process. But if I could ask a supplementary to that, which is the well-reported concern by many members of the judiciary and of the bar of the sometimes appalling representation defendants receive, especially in the increased use of solicitor advocates as opposed to barristers. And I wonder whether you could comment on that. Give me your view about whether you feel that this is a trend or whether this is something that they are unduly worried about.
Well, the LSC has been pushing very strongly for a quality assurance scheme for advocates. And in one sense, we've taken up this role as a quality regulator, perhaps in the absence of action by the other regulators. But I know one of my commissioners, David Wolfe, who is a barrister, was instrumental in pushing forward this work. The QAA scheme is now, as it were, the property of the regulators, a joint group, and it was responding, as you say, Mr. Gummer, to complaints from the judiciary, and Lord Justice Thomas was a leading figure in pushing this work forward. So I know there's been a lot of issues around higher court advocates, but we think the QAA scheme is the best way to objectively test quality, whether that's provided by a solicitor or by a barrister.